Good afternoon, everyone. Welcome to today's webinar to learn about the latest HOA and condo legislative updates for 2024. I'm thrilled to have you all join us as we delve into this important topic. My name is Aileen Zorilla, and I am the Business Development Manager for the Broward region here at Castle Group. And I'll be your host for this session alongside my partner, Millie Ventura, the Business Development Manager for the Palm Beach region. Today's presenter is attorney Barry Ansbacher, founding partner at Ansbacher Law. Also with us today is Diana Sayas-Basan, Director of Marketing and Communications. Throughout the webinar, our panel of experts will share latest updates on past and pending bills and explain how these changes will impact you and your community. I invite you to actively engage by asking questions in the chat. In the screen, you will see how to submit a question. And these are the instructions in case that you need any assistance. And to ensure we make the most of everyone's time, we'll address all questions at the end of the session. Barry will also be sharing with everyone that's attending all the slides as well as the bills. So that way you can refer back to it as needed. Thank you, everyone, again, for your participation and understanding. Before we kick off our session, Barry, would you like to introduce yourself and tell us a little bit about Ansbacher Law?
Well, certainly. I'm going to let Diana Zayas do the honors. I do want to introduce Diana, who's out of our Fort Lauderdale office, our Director of Communications and Marketing, and my colleague who's just going to be with us, a chance for y'all to meet her, Alejandra Gonzalez, who's one of the many attorneys who serve our association so well on our community association legal team. With that, I'll turn it over to Diana.
Thank you, Barry. Thank you, Eileen. Thank you, Millie. And also thank you, Alejandra, for being here with us today. As you all know, I'm Diana Zayas-Basan. I've been involved in this community association industry for over 20 years. Most recently, you might have known me with Angus and Terry, construction defect attorneys. We joined forces with Ansbacher Law. The Florida office is now joined with Ansbacher, and we are one team, so we've joined together. Our Barry Ansbacher has been specializing in real estate, construction, and community association law for over 35 years. He is established as one of the Florida leading attorneys and has achieved board certification and is recognized by the Florida Bar as a specialist in 3 practice areas of law: real estate law, construction, and condominium and plan development. Barry is the only lawyer in Florida who holds 3 certifications, and he's currently the chairman of the Florida Bar Condominium and Plan Development Certification Committee. Alejandra is one of our attorneys that has recently joined us. She graduated from University of Miami, not graduated, sorry. She got her law degree from University of Miami here in our neck of the woods, yay. And she has been with us for a year now. Also, I wanted to let you know that Ansbacher Law has a statewide presence. We are statewide, and we have offices in Jacksonville, which is our corporate office, Fleming Island, Ponte Vedra Beaches, St. Augustine, Orlando, Tampa, and Fort Lauderdale. Thank you again, and Barry, let's give it to you now.
Well, thank you, everybody. Thank you, Diana. Thank you to Eileen and Millie and the wonderful folks at Castle for inviting us to speak with you here today. So what I'm going to do today, because we have a limited time period, I'm going to abbreviate and really focus just on a few of the bills today. We are going to, with our friends at Castle, send you everything. So you don't need to be frantic. All the slides are going to come to you, as well as all the bills and laws and court cases, even the ones that we're not necessarily going to have time to talk about today. We are also going to have time for questions and answers at the end. So I'm going to just ask you to hold your thoughts till then. So I'm going to go really briefly through the legislative process. But what I do want to point out is this. You're going to hear about some bills that became law and some bills that are going to become law. And I don't think you're necessarily going to like all the provisions in there. I'd suggest that some of these provisions are going to make your jobs as community leaders, directors, and officers more difficult. And so what I always like to remind people is if the community leaders don't have input into the process, then we don't always get heard in Tallahassee when they pass these laws about our concerns and issues. So I encourage everybody to do so. So the first one I want to talk about is House Bill 1029. Now, what happens is you remember, back to Schoolhouse Rock, where I spent many a Saturday learning my grammar and legislation. Laws pass. In other words, I'm just a bill. I'm not going to sing. Don't worry. But laws pass the Florida House or the Florida Senate, and then they have to go to the other side. So they need to pass both the House and the Senate within the 60-day legislative session that happens every year. If the same law passes both bodies, then it is called enrolled. That means it is now ready to go to the governor. However, the governor doesn't receive them all during the session. The governor tells the legislature when to send them the law, and then, the bill. And then once the governor receives it, then the governor has time to either veto it or approve it. And that's why it's many months after the legislative session is over before we know what will actually become a law or what bills the governor may choose to veto. So we've identified which are laws. So where you see it here, 2024-108, that was House Bill 1029, but it is actually now a law. And if you see the statutes, which are still 2023, but once they re-update them, they will be online in 2024, and you'll see these laws. Now, what we have with this MySafe Condo program, it's an opportunity for condominium owners to participate in what had been MySafe Florida Home Program. It is a grant program that the state of Florida makes available for coastal communities only to harden their buildings. And what the goal is really two parts. One is to encourage condominiums to do inspections to determine what can be done to make the building safer. And the second part is if the condominium association chooses to make the improvement to help subsidize the cost of those improvements. Now, these are only available if you're within 15 miles of a coastline. And this is the other issue. It is a requirement that not only does the board need to vote for it, but if you're actually going to apply for a grant and make the improvements, this is a real crazy requirement. To get the money to do the grant, everybody in the building, unanimous consent must approve for that. And as we all know, getting unanimous consent to agree what day of the week it is in a condominium association can be difficult. However, the inspection requirement is a little less onerous on that. The inspection requirement only requires a vote by the board or the condo membership. So communities may find that they can at least get that available subsidy to have an inspection, but the improvements are really going to be onerous to get a vote for all of it. Now, there is money available that's matching. So the association spends $1 and then the state of Florida does a $2 match. But there's a lot of conditions and requirements. One is that there's a bunch of caps on that. For example, the total any association can get, no matter how many units, is $175,000. So that's fairly limited with how expensive it is to make improvements to hardening. They also have caps for roofs, windows, and doors. So for a roof, it's $11 a square foot, or $1,000 per condo unit, 50% of the total roofing. Or for a window or door, it's $750 per window or door, or $1,500 per condo, or 50%. So there's a lot of restrictions. The uses that are allowed are to harden things. For example, to protect window openings, door openings, skylights, reinforce the roof to wall connection so the roof in a hurricane event doesn't get pulled off the building, reinforce the attachment of the roof to the deck, provide weatherproofing for the roof. But things that don't apply include a really interesting one. You can't make the same type of improvement that you previously made. Not quite sure what that means, but for example, it might be that if you came in and replaced non-impact glass with impact glass on half the units, you can't keep doing that. They want you to do something new. We'll see where it goes. What's interesting is that the money is going to be, this is a pilot program, is going to come and go, and they have to first adopt the rules, but then you want to get on that list. There's a total in the appropriations bill, and we don't know if that will be final because the governor has a line item veto. But the total money that was allocated for this program statewide was 25 million. So if you look at the number of condos, that's not going to go very far. And when the money runs out, the money's out. So you're no longer able to apply. However, if the program does go well, there's at least the expectation that they would add funding for future years. And that's what happened with the single family residential programs that they did that. So something to keep in mind. That's a little bit of the good news. A lot of the stuff I'm going to tell you is the bad news, but that was a little good news. Now, here's another issue that I think really highlights just how important it is to get involved in the legislative process, either through direct contact to your state representative or senator, or I encourage a lot of people to get involved, and your good folks at Castle will know how to get you on board with the Community Associations Institute, which is the organization that your managers, your association attorneys, and many directors belong to, which helps to provide a voice to the community association, both the professional community and the community leaders. And this is a good example. Senate Bill 278 would have placed a lot of cost and burdens on the association, and it was essentially a bill that was intended to help title insurance companies and closing attorneys to reduce the cost of transactions and to put more of the burden on the membership for that. And this would have put a lot of burdens, a lot of risks and problems on associations. And this is one of those victories. And a little bit of celebration is it didn't pass the legislature. And that was a direct result of people like the folks at Castle and others in the community association world that brought the concerns regarding this bill and the negative impacts to the attention of the people in Tallahassee. Now let's talk about what is going to be the big HOA bill. Now, one of the things I always like to tell people is, hey, don't tune out. If you're in a condo association, don't start covering your ears and say, not me, I'm in a condo. Likewise, when I talk about a condo bill, don't tune out. And here's why. The legislature has a pattern of getting a law through the process on condos, and a year or two later, they'll even up in HOAs will have the same or very similar regulation, or vice versa. Sometimes the HOAs go first. So almost inevitably, any law or regulation that's applied to one of the community association entities like a condo are going to be HOAs and vice versa. So, and this is a real good example. So this law affects Chapter 720 homeowner associations, not directors. But some of the things that we're going to talk about already affect condos, and the ones that don't, I will say with a near certainty will, if not in 2025, certainly maybe by 2026. And we'll go through some of the examples of what is now going to be law in Florida as of July 1, 2024 for our homeowner association communities, and will likely become law in the future for condos. So first is the community association manager must personally attend in person one member meeting or board meeting a year. That's interesting because what if you have a community that doesn't have in-person meetings in terms of all physically being present, all by Zoom? It doesn't address that, what it means in person. And I think it's a fairly minimal requirement. I don't know many communities that don't have at least one meeting a year of membership or board in attendance, but that's a new requirement. Now, the next one is one that affects condominiums already. If you're in a condominium with 100 or 50 or more units, this has been the law for 2, 3, 4 years now, that you have to put most of your official records on your website, or you can use an app like an iPhone app or Android app, though I'm not aware of many communities doing that. Now, I've been telling people in the HOA world, this is going to be coming for years, and this is a good example of the catch up. And now it's going to apply. And here's the issue that's really going to be a challenge is you have got until January 1 of next year to get these things digitized and online. And I've been talking with the good folks at Castle. They're already working on helping associations do that. But if you think about the cost of scanning, digitizing, getting it all online, and setting up the password protections, all like that, if you're not already in the game, it's going to be here before you know it. And that's going to be real onerous. The good news is once a community gets this information online, it really alleviates a lot of the disputes over making records available. So once you get there, it's going to be really, really helpful. Want to go back a little bit back to the CAM requirements, and this is always helpful for people to understand. I think everybody who deals with condo and HOA law knows that you look at 718 for condos and 720 for HOAs, but you have to remember your lawyers are regulated by the Florida Bar and your managers are regulated by the Department of Business and Professional Regulation. So if you ask the good folks at Castle to do certain things, sometimes they might tell you, hey, we've got to do it a certain way because they are licensed by the state and have certain requirements. And I shared with you that they have the duty to attend a meeting in person, and that's whether you want them to or not. That is a licensure regulation. But now they are also going to have to provide the name of their manager, the contact information, office hours when they're available, and a summary of duties. And that has to be posted on the website. But you have to provide that information to all your members. What's not clear is how do you provide it? It's unclear if that's going to have to be provided by a special notice, special meeting, what you do it. I'm not sure. I would suggest that information I'm going to recommend to our clients, unless the division comes out with guidance, that be done as part of your annual meeting notice. Seems like a logical place to put that. They are also doing things for our management community to make sure that our managers are well educated and informed, and they're significantly increasing the education requirements that your managers have to take each year to maintain their licensure status. So I guess that is a good thing to make sure our managers are even better trained and available to assist you with the knowledge that they need. Now, one of the other changes that we have is under 720. They've explicitly said directors are subject to Chapter 617. In particular, they're saying you have to meet the standards applicable for all directors of a nonprofit corporation. And if anybody's ever attended one of my board certification classes, you've heard me go through it. What that means is explicitly, if you're an HOA director, you have a duty to act in good faith and in the best interests of your association. But this is something I want everybody to be sure that you understand. Explicitly, you have to act as an ordinarily prudent person. That means prudence, caution, conservative judgment in terms of the investment of the resources, in terms of the decision-making, in terms of your insurance. That is now a specific obligation for every HOA director. I think it's always been implied, but the legislature has made that explicit. One of the big emphases of the legislature this year is to make records available and not to hinder access to homeowners. And where did this come from? Well, the legislators hear horror stories. Somebody picks up the phone and calls them and says, hey, we have directors that aren't providing this information. We think that there may be embezzlement going on in things. And there's been some very notorious cases that came out of that. And what happens, the reaction is we're going to pass a law. Now, I would suggest to you that most of the bad behavior that was prohibited already. In other words, it was always illegal to steal. It was always illegal to commit fraud. But the legislature is really going to tighten down on this. And they're doing so. For example, your managers now have an explicit requirement for education just on record keeping and retention, and so will directors. So one of the things they did first is to clarify. The legislature previously had said, for example, minutes need to be maintained perpetually. And then they've gone back and forth, but now they've made it a little bit simpler. All official records, and I'm not going to go through the whole list of what it includes, but it's pretty much all your governing docs, everything in your operation and so on, but it's all under 72303. They've now made it simpler. The minimum time to retain records for anything is 7 years. But if your governing documents have a longer period of time, then it's whichever is longer. So now that's made it simpler, 7 across the board or more. The other thing that they're requiring you to do, and this is new, I don't know many associations that have it, but now even if your articles, bylaws, your declaration have a record retention policy, you are now required to adopt written rules on how you're going to implement that. So every single association is going to need to do so. I don't know many that have an explicit rules. If you do, that's great. If not, you're going to need to do so and adopt those. The website requirement, we talked about it's due January 1, 2025, but there's going to be more stuff that needs to be on the web. Most associations are probably doing this. Some may not be. So this applies to all associations, not just 100 or more units. And that's going to be your meeting notices for your member meetings have now got to go on the website, and your agenda. But this is probably new to most of you. 7 days in advance of the meeting on your website, whatever's going to be on the agenda, documents voted on, considered, it's got to be posted. Also new, the board meeting notices need to be on the website. This is in addition to posting it into your community, but the agenda needs to be posted. Now, you may recall last year, HOAs started to have the requirement of posting agendas. That was new in 2023. It's been in condo requirement for many years. It was added to HOAs. Now they're going further and saying that the agenda needs to be on there as well. And the timing for the posting of the website is going to be the same 48 hours for most things and 14 days for things like adopting a special assessment or changing your rules. Now, let's talk about the protection of data. That's what makes it so expensive and time consuming, because you are required to remove all the confidential data before you put it on the website. So it's not just a matter of finding some people at the Kinko's or FedEx shop and saying, scan it all and throw it online. Somebody has got to review it and redact or black out the confidential data. And this is not new, what's confidential data, but remember what this involves. Anything attorney-client, anything you got from an applicant to lease or approval for a tenant or a purchaser, your gate visitor logs, medical records. For example, somebody provides that, social security numbers, driver's license numbers, credit cards. Maybe those aren't so difficult, but listen to the really tough one: email addresses, phone numbers. Now, I don't know about you, when I get an email, it always has the sender's email address. Think about that. Since so much information comes from email, how are you going to redact that and deal with it? Now, this is new. The requirement to redact has always been there, but it's always said that you had no financial liability if you violated it. In other words, a court or DBPR might order you to comply, but you weren't liable for money damages. Now they've added a requirement that says, if you knowingly and intentionally disregard that duty to protect data, you say, we're not going to bother, it's too expensive, you now may have liability. So think about that. I don't know the circumstances where it might be, but somebody may have a former spouse that's stalking them. There may be some other financial implication, and you may have liability for that. And that's also very important when you think about your insurance. Is that a risk that is covered under your directors and officers liability insurance, or are you going to need a specific cyber liability policy? Something to think about. It's part of this same spirit. The legislature has been tightening up, making the governing documents available. So now it says, unless your governing documents provide otherwise, you've got to make everything available within 10 days, 45 miles. Nothing really new there, except they're now saying your governing documents or the law may make it even tighter. Another little tweak they did is the request must come from a parcel owner. So they've made it clear you don't have to respond to an inspection request from a tenant. Now, what about if it's from the parcel owner's lawyer? We would suggest it's not worth fighting on. I know some associations feel otherwise. I don't think it's worth fighting on, but it's on there. Here's something you're not going to like. You are a volunteer. You're not being paid. You're serving your community. If you, and this could also apply to managers potentially, do not allow inspections within that 10 days or allow them inspections to everything they're entitled to. And here's the key: with the intent of harming the community or even a member, you're in a fight with the member, you could be charged with a crime, a misdemeanor. If you deface or destroy or don't maintain, do not maintain an affirmative duty all the required accounting records, you could be charged with a misdemeanor. And if to protect from a crime, you destroy records, you could be charged with a felony. That one is not so much of an issue. That means that you were stealing or doing some underlying criminal act, but it's there. Finally, there's one other tweak on records. If you get a law enforcement subpoena, you only have 5 days to respond. And I think that may catch some people because the subpoena itself may provide a longer period, but the statute now says you only have 5 days. So now let's move a little bit into financial records issues, what we're talking about with financial records. So reminding everybody, for both HOAs and condos, there's a threshold of whether you need an audit, a review, a compilation, or just a P&L statement at the end of each fiscal year. So for HOAs and condos, it's always been the revenue of $500,000 or more. You need a CPA to get an audit, or your membership, which certainly we don't recommend, can vote to waive that. So what are the changes they made? Change number one, if you've got 1,000 units, you need to get an audit. Change number two, your members cannot waive the audit requirement 2 years in a row. So if they vote to waive it in 2025, then in 2026, you have to have an audit. There is now another new requirement, brand new, that says if a member, this is a big one, please listen carefully. If a member sends you a written demand that says, I want a financial accounting of my records, you have 15 days to respond. And if you don't respond by 15 days, listen to the outcome. All outstanding fines gone, not collectible, gone. Number two, anything which is 30 days or past due, gone. And if you have fined somebody, but you haven't given them the notice imposition, in other words, something in progress, that's gone as well. So it's a real big penalty. Now, part of all these new laws are to make sure that members of the board of directors are educated. So we talked about that they've increased the education requirement for your professional managers. They have increased the educational requirement to serve as a director of your community. So let's talk about the prior law. Prior law was 90 days after you were first elected or appointed, you had to do one of two things. You had to attend an education class specific to board certification. Our firm offers them, Castle offers them. Or you could sign an affidavit that said, yeah, I read the governing documents of the law, I know it, and you didn't have to do the education requirement. The affidavit option is gone. Everybody has to do the education requirement, period, paragraph. Number two, the education requirement has to be the specific board certification. So it has to be approved for that purpose. And if you're on the board, every 4 years, you've got to repeat it. So that education requirement is good, 4 years only, and then needs to be repeated. And now they're providing guidance to educators like Castle and Ansbacher Law that we need to cover specific topics, financial literacy, record keeping, fine notice and meeting requirements. And we already include that in our course, so that's not an issue. So let's listen to another requirement. That was always a one and done. Now it's an every 4 year. But now there's an annual education requirement. So one is the director certification 4 year, and the other one is every year. Now, the every year requirement is if you're in a community under 2,500 homes, it's 4 hours a year. If you're 2,500 homes or more, it's 8 hours a year. And they are looking for HOA specific classes. They made some other criminal events in terms of taking illegal kickbacks, which of course nobody should be doing, and they've made that a felony. They've come back and regulated architectural restrictions some more. Why? Because people complain, my association's picking on me. They hear a horror story and they come back and say, well, we'll stop that. That's one of those issues that a lot of people don't hear the other side about, the neighbors who are putting up with all these violations and problems, and the association and management are trying to protect the neighborhood. But this is important to hear. One is architectural review committees have to be equitable and reasonable in enforcing the rules. So in other words, you can't selectively enforce. What does that mean? That means you probably just can't rely upon enforcing when you have a complaint, but you're going to need to build into your management services that the managers actively identify, report, and prosecute violations so it's uniform and fair to everybody. Number two, you cannot adopt a covenant rule or guidance that regulates what people do in the interior of their home unless it is visible from the exterior. Now, excuse me, what are we talking about? What we're talking about is if you have, for example, you can't have drapes with signs on them or things like that, that would be something on the interior. Now, here's one that you can see that they had a lobbyist. The HVAC air conditioning industry has a lobbyist, and he probably is high-fiving right now because they now provide very specifically, you cannot regulate HVAC systems. Normally, we're talking about screening the exterior compressor if it's not visible from the front or a side parcel, and it's the same type of system that has been applied elsewhere. Let's go a little bit further in terms of the requirements. They're now saying if you deny an ARC request, you need to cite exactly the verse and chapter of the basis. In other words, you can't say we're denying it because it doesn't meet our color standard. You're going to have to say section 2, page 3 of the ARC guidelines, or the fence is too tall that you're proposing, paragraph 72 of the declaration. So that needs to be in the denial notice. We've come back now. If you remember, a year ago, they said you cannot enforce violations if they weren't visible from the front or an adjacent parcel. They've dealt with that a little bit and said also if it's visible from a golf course or common areas, you can enforce it. And they've added a couple things more, not as an exclusive list, but as an item that they're saying in particular, we don't want you enforcing these if they're not visible: vegetable gardens and clotheslines. Now, clotheslines were always subject to energy protection restrictions anyway. So let's talk about fines and suspensions. Historically, if you had a fine, in other words, your manager went out and said, we gave you warnings, here's a fine, you're now fined. It was like getting a speeding ticket. You didn't have to have an appellate hearing, but you had to give them 14 days that they could request a hearing. And if they didn't request a hearing, then the fine would be automatically imposed, meaning it would become a receivable payable by the owner to the association. Then last year, or maybe the year before, they changed it where it appeared that you had to have the appellate hearing whether or not it was requested. This last year, they've changed it yet again. So in 2024, it now says the notice is not of a hearing, but of the right to a hearing. So it seems like they're going back to the opportunity for a hearing. I will suggest to you what we recommend regardless is the best practice is to always have a hearing for two reasons. If you ever end up in front of a judge, the judge will know that the board and the manager were double checked by the independent hearing committee. It always provides a comfort level for the court to know there was due process. And two, that way, all these people aren't coming to your board meeting complaining because they've had that independent review to make sure that everything was above board. They've added some requirements in terms of timing. The hearing committee, and a lot of people call it enforcement committee or violation committee. I like hearing committee, but it's all the same thing. That now has to be within 90 days of the fine. The hearing committee now can be by Zoom or telephone conference, and you have to allow the owners to participate. Another timing requirement is you've got 7 days after the hearing to tell them, yes, thumbs up, that fine is going to be imposed, or suspension, or thumbs down, we're not going to do so. And this is going to be a big burden. Listen carefully on this one. The fine is not due until 30 days after they get that notice due after 7 days. Not too bad. But listen to this. If the fine is paid before that 30 days, no attorney's fees, no cost. But this is the toughest one on it. That if the violation or fine is occurred before the hearing or within the time demanded, you can't fine them. So let's say you give them a fine notice that their house is painted the wrong color and it's been there for 60 days. You've had all this effort and you go and they slap a coat of paint on an hour before the hearing. You go to the hearing, you go to all that effort. They walk in and said, I fixed it. You can't do anything. So in other words, it's almost like giving them a grace period all the way up to the hearing. And presumably they could do the same thing over and over again. It's going to be a challenge. And also, if they cure it within the time of the hearing or appeal, you can't get any attorney's fees and costs for any action taken by the board. And that may arguably touch on injunctions and such too. So we're not done yet. Some new limitations on garbage cans. We have amnesty for garbage cans. We always had you can have a gazillion different types of flags. Now your garbage can proudly be in the front of your driveway on the curb. It says 24 hours, but it's really 48. You can put your garbage can out there 24 hours before the scheduled pickup and leave it there for 24 hours afterwards, and you're not allowed to enforce it. Another amnesty. Holiday decorations or lights are not enforceable in terms of fines or violations without giving them a 1-week courtesy notice. Now, remember, most people, when they think about holiday decorations and lights, are thinking usually Christmas and the more known holidays. State of Florida has holidays on the books from Robert E. Lee's birthday, Juneteenth, day before Thanksgiving. So there's nothing that says which holiday. So arguably somebody could keep putting their holiday lights out or whatever. Pink Flamingo, I'm celebrating Flamingo Day. Every time you get the notice, they have a week. Do it again and again. So it's really going to make enforcement of those type of restrictions very difficult. And the last one is parking of vehicles. Let's talk about this one. Any owner or guest, their tenant, cannot be restricted from parking their personal vehicle, including a pickup truck, in their driveway. Many associations says you got to put it in your garage. If this law applies to your community, meaning that constitutionally it applies, and I don't have time to go into that, but assuming it does, that's gone. They can park it in the garage, in the driveway. And it doesn't matter if the vehicle has official insignia or visible. In other words, it can have commercial lettering and logos on it. Let's go number 2. The only type of vehicle that is not allowed if it's owned by the occupant or the property owner is if it's a 26,000 pound or 3-axle vehicle. Think about that. That's a lot of vehicles that are under 26,000 pounds. Another restriction is you cannot do any protection of licensure. Some communities don't allow contractors in their property without proof that they're licensed, proof that they have an occupational or license, for example, a general contractor, plumber, such like that. No longer allowed, no longer to limit people to preferred vendors or required vendors in their community. Some communities say you have to use an approved general contractor for quality control. That's not applicable. And last, any first responder vehicle can park where they want. Also, crimes for election fraud. So you can see there is a lot of things all packed up into that law. House Bill 1203, which is now law. I'm going to jump to House Bill 1021, which is condos and co-ops. Now, this has not been signed by the governor yet. I'll go a little bit quicker from that. The governor might veto it. The governor might allow it to go into law. We don't know, but we'll know within a few weeks. So let's go here. CAMs now have 20 days to turn over their records upon request or a change in CAM. There is now a lot more restriction on conflicts of interest. If the manager, anybody who owns any interest, officers or directors of the management firm, or any relative, their third cousin twice removed, has any interest in the vendor, if it's $2,500 or more, they got to get an extra bid solicited. They don't have to procure it. There may not be another bidder. They have to provide disclosures on the meeting notices, on the agenda, and the meeting minutes. And If it's a conflicted existence, it requires 2/3 of the directors to approve it. And then you have to notify the members that a contract has been entered into. So that's going to require some issue. I don't know how, if I'm the manager, I know every shareholder, every owner within the company, and owning a financial interest. Let's say you're dealing with a public company, let's say Comcast. How do you know who owns shares in Comcast? It sounds great in theory, not so easy to deal with it. There's now a duty to keep your records in an organized manner, which I thought is interesting. That'll be interesting to have a debate over that. There is now, similar to what we talked about the HOA, if you knowingly and intentionally disregard the duty to redact protected information, just like in the HOAs, you can have financial liability. Some other requirements. You're going to love this one, condo directors and managers. If you have 10 or more units, you must have a board meeting at least once a quarter. Not so bad. Now you must allow questions to be asked by members. We've always allowed comments. Now you have to allow questions. Now, if we're going to be really technical, it does not require you to give answers, but it does allow them to ask questions. So we'll see about that, where that lands. And you have to provide contracts that are under consideration. House Bill 59 is another one which adds additional rules, regulations, and requirements. Some of them are duplicative of the law that we talked about, but I do want to allow time for questions and answers. So knowing that we are in a limited time period, I am going to stop here, and I'll ask the good folks at Castle to shoot some questions, and I'll do my best to answer them. As a reminder, everybody, this is not the place that I can give advice to your association for legal advice. I always tell people, if you're going to confess a crime, don't do it at an open webinar. Likewise, without having your governing documents in front of me, without understanding all the facts and circumstances, I would be giving you an answer that would not be reliable, and it would be unfair to the other participants to get that far in the weeds. So we're going to ask for questions of general interest on the topic. And with that, I thank you, and I'll turn it back over to Eileen and Millie.
Thanks so much, Barry. That was very informative for sure. So one of the first questions that came along has to do with the documents. It says our documents do not have the Kaufman language. So do we come under the changes even if we were established under 617 in 1995?
Okay, well, I'll share a couple of thoughts with you. When you talk about constitutional law, those are the fancy lawyers. And I'm not a fancy lawyer. Now, let me explain why. The theory of Kaufman language is this. If your covenants were recorded in, say, 1990, that's the equivalent of everybody who is a party to that community signing a contract in 1990 based upon the law in effect in 1990. So constitutional provisions that say you should not enact laws that change existing relationships, ex post facto law, is what we're talking about. So arguably, a law that is enacted after the date of your declaration would not apply to you, but it's not that simple an analysis. The next analysis is the law one of procedure? In other words, you need to give people 10 days warning before you file a lawsuit, or is it substantive, saying you can't prohibit certain types of vehicles? In other words, is it about the process, or is it a substantive? If it's process, the courts have generally found that that's fair game because they're not taking away your rights. They're just making you exercise those rights in a different manner. If it's a procedural, then other than a slight exception for life, health, safety issues, those laws don't apply to you. But we're not done yet. If you look at your governing documents, some governing documents say our community is subject to the laws in the state of Florida. That doesn't change the analysis. But other community governing documents say our community is subject to the laws of the state of Florida. And here's the magic words. If you're a Harry Potter fan, this is the spell words, the magic words, as amended from time to time. That's called Kaufman language because that's the lawsuit where they said those words mean any change in the statutes are automatically applied to your community, even if they're after that date. So you have to look at the law. Is it substantive? Is it procedure? Is it life, health, safety? And what are your governing documents have? But we're not done yet. Here's the issue. Let's say I do that analysis and say, hey, I don't think this applies. Now, here's the issue. If you go to enforce it, most judges are going to look at the statute book and say you're violating it. And you say, but Your Honor, it's not constitutional. And they say, that is a great thing, Mr. Ansbacher, go tell the appellate court. The point being, if you're going to base your decision-making on making something that is unconstitutional, the center of your argument, the basis, you need to be prepared to argue that all the way up to the appellate court or Florida Supreme Court. So for me, not so much of a problem. My daughter's in private school. I've got tuition to pay. I'm happy to do it. For you and your fellow members and associations, that's a lot of money to spend. Likewise, if you have insurance defense, in other words, let's say you enforce something and somebody says my 25,900 pound vehicle with, Joe's termite shack painted all over it is a personal vehicle, and you go to enforce it and they sue you. And your insurance company hires a lawyer for you. There's a real question. Will that insurance company pay to appeal an adverse verdict at trial all the way up to appeal? So in the real world, it is swimming upstream to enforce something that's different than the black letter of the statute, even though it may not apply. I know that's a very long answer, but this is a really important point, especially when you have some communities that this will fundamentally change what they believe is the nature and character of their community.
Absolutely agreed. There's several questions about what is an official record. What needs to be posted in governing docs, or what is official records entail?
Well, I think on that, your best source of what's official records is to talk to your community association manager. I don't try and rehearse the list by heart, but 718 and 720 both have a long list of what those documents are. In general, it's basically everything that the association touches, creates, or receives in its operation. I mean, it's really pretty expansive. The list of documents that have to be uploaded onto the website is a little shorter list than that, but not much different. So that's one you need to have a discussion. Every association should be sitting down with their manager, not when you're getting sued, not when you're fighting inspection, because they say, hey, let's have a vision process of how are we going to get this stuff digitized, redacted, and let's find a way to do it where it's not a fire drill and get ahead of it. That needs to be a long discussion that I think everybody needs to workshop, and it's not necessarily going to be a cheap discussion. So I think a lot of people who haven't budgeted in the 2024 budget year for this are going to be facing a shortfall, because it can be tens of thousands, depending on the size of the community, to 100,000 or more to accomplish this if you don't already have digital records.
Okay, for the posting of notices, 14 days, is that just for the annual meeting and budget meeting, or is that for all board meetings? And does this also apply to condos?
For both condos and HOA, the generic board meeting is 48 hours unless there's a declared emergency in the state of Florida, or the board of directors has an emergency like, hey, if we don't meet and authorize this check by the manager, the lights are going to get turned off, that kind of thing. The 14-day notice for board meetings generally applies, and I may be missing one, but off the top, when you adopt your assessment or a special assessment, when you adopt a new rule or regulation or amend them, if you authorize electronic voting, and I may be missing one, there's another I think for preservation of covenants. I may be missing some others, but the 14 days is not standard. It's for those special items. Everything else is a 48-hour notice.
Thank you. Regarding the parking, does that also apply to condo? And there's a question regarding an RV vehicle, because would that also be included in the HOA law with the parking?
That law does not apply to condo, but remember, the same legislators who heard people whining that I can't park my 25,000 pound vehicle in the driveway and it ain't fair, they're not going to feel any different about it if they're parking in their condos. So you're going to see similar push for this in the other. Is an RV a personal vehicle? It might be. I don't know what the weight of it is, but you know, I've seen RVs that at least I would think might be less than 26,000 pounds. The one thing that they did is, you know, specify pickup truck. You know, the Ford F-150, you know, folks were very loud and proud. They don't specifically say including an RV, but they don't exclude it. So if it otherwise met the criteria of personal vehicle. And now, what is a personal vehicle? I guess if somebody's driving it to work and back and they drive an RV, I think it might apply.
Great. I had there's a question regarding if you can't regulate inside the homes unless visible from the outside, can you enforce a no pet policy?
I think that that's in terms, as I read it, architectural standards. Unless the dog is, you know, a taxidermy and stuffed, or I don't think it would qualify as a decoration. I know my wife thinks the prettiest thing in our home is our multi-poo, but I'm not sure that would qualify as an architectural item. But I hadn't thought about that context, but I don't think it would go to that. I think they're referring more to drapery, blinds, and there may be some communities that, I don't know why they'd be regulating the color of your carpet or floor tile or such like that. I'm guessing that there was probably an association that wasn't managed by good folks like the people at Castle, or had good directors that may have misunderstood ARC, and they probably were telling them what color their dishwasher had to be, and they went and complained to their legislature. So I've never been involved in I'd invite the folks from Castle to share where association was regulating the interior other than what could be seen through the windows. Have y'all ever seen that? Because that would be not something I've ever experienced.
No, we have not. Okay, what happens if a management firm doesn't turn over the association documents within 20 days?
They are subject to certain penalties, including the right to terminate the contract, I believe, and not pay termination fees. They're subject to fines, licensure violations of the CAMs, you know, all sorts of bad things that follow. I will tell you, they're changing it from 30 to 20, which to me is a little bit ridiculous, because we usually work on a monthly cycle, and you want your current management company, if you're changing, to close out their books and reach a point in time. I've never seen that as an issue, with very rare exceptions. So we'll see.
Back to the parking question, and I have this in my own community. So that the community does not allow vehicles to park on the street between 2 a.m. and 6 a.m. Will they now need to cease that practice as of July 1st?
Well, when you get into the weeds of the statute, it has two different rules, and they have to be read very with a fine-tooth comb. One rule is allowing them to park in the owner's driveway. The other one is allowing them in the community on the private roads or the public roads. Now, one of the things you get into is, if it's a public road, it's unusual, but some communities say even if it's a public right-of-way, owners aren't allowed to park in certain locations, even though you couldn't enforce that against just a member of the public. If you're dealing with a private road, it really brings up an issue, because that's not the owner's property. That's my property as the association. That strikes me as an example of one that might be a constitutional issue, because you're really saying what you can regulate in terms of your property rights. But there's a different analysis on each. I would, with the time allotted, it's probably too granular, but that's something that is going to have to be drilled down on. It's not the same with it. Likewise, if your community you're in, let's say you're in the city of Parkland, and they have restrictions on parking vehicles of a certain size or type on the streets or parking in certain hours, I think the association could certainly likewise enforce, parallel to the government documents, that, hey, this is not allowed parking on the street. So that would certainly be one area of approaching it. And so some of this may be also approaching your city or county officials and asking them to enact ordinances in terms of no parking or parking limitations.
Got it. We had a question also regarding the board certification course. If you're a CAM, and you're also on the board of that association, are you required to take an additional 4 hours?
If you are a CAM, you are a lawyer, you are the director of the division of condominiums. There's no exception. There is not a single, if I teach the classes, but I would have to take it. So the answer is there is absolutely no exceptions allowed for it.
And where can we find these educational curriculum?
Well, the division moves at a glacial speed. And we're not talking about the global warming glaciers. We're talking the 1950 glaciers. So by the time they enact rules and approve the courses, I don't know when it's going to be, but that's like one of the frustrations. We cannot teach an official 2024 certification class probably until, legal update class probably till August, because it takes the division that long to approve it, even though most of the laws become effective July 1. So how long it will take, I don't know. I know Diana at our office is already working on putting together the curriculums and the courses, but when DBPR will approve it, I would have no idea. I imagine it is likely to be after the time you were already required to comply, but it's out of our control.
Good. Regarding the 7-year requirement to hold association records, is that just to be retained, or is that also to be posted on the website?
Two different requirements. Remember, the 7 years is unless your governing documents have a longer period. So it may be longer. And let me be clear too. There is no reason in the world to ever destroy minutes or things like that. In other words, now that you're digitizing records, another gigabyte is probably all your records to the beginning of your association. And there's always a value of institutional memory. So I'm not recommending people delete stuff just because you hit that time period. But the duty of what goes online is not the same as what you have to retain. But as a practical matter, I think you're going to basically parallel the two. In other words, instead of trying to keep some in one manner and some another, I think when you sit down with your managers and your IT professionals, you're probably going to want to only have one repository plus the community association management firm's back office, management software. I don't know that once you've digitized 80 to 90%, is it really going to make sense to have separate paper files and such? But I think that's part of what I'm recommending, that you really sit down and workshop this with your management company, because lawyers can give you the law and that doesn't mean anything. You need your managers to sit down and let's translate it into practicality. How are we going to get here from there? What's the most efficient, cost-effective way to do it? That's the real serious discussion.
Thank you very much, Barry. The recording of this webinar will be available at castlegroup.com, and you'll be able to find all of the previously recorded webinars as well. Again, Barry and his Ansbacher team will be sending over this presentation, so you can refer back to it. And thank you all for joining us today. And thank you, Barry, for the insightful information.
Thank you so much for having us. Everybody, wish you a wonderful day, and thank you for attending.